I was just trying to get the slideshow. Yeah, now I got it.
Okay?
Good. Yeah, just had the whole screen.
Yeah, it's everything I put in the same folder.
Thank you.
Yeah, I can take it from here, and if it would be easier for you to sit next to the, I took the chair.
I'll probably use that. Okay. I'll probably stand up because I think the mic works better up there.
Shall we start? Good afternoon. My name is Yaakov Kobi Sharvit, and I'm grateful for the opportunity to chair this panel. I had the Litigation and Dispute Resolution Department at the law firm of Herzog, Fox & Niemann, and I specialize in class action defense, including, or specifically, multinationals and consumer class actions. It gives me great pleasure to welcome all of you to this panel, and which is comprised of an esteemed group of speakers. The issue of ADR and settlement in collective disputes is obviously of great importance, at least in Israel, as you've heard before from Chief Justice Grunis. The vast majority of petitions for certifications of class actions end up eventually either in withdrawal or in a settlement. This issue obviously raises many interesting questions, some of which will be explored by the distinguished speakers of this panel. So I will briefly introduce the members of our panel, and they will each make their presentation. Our first speaker is Professor Francis McGovern. Professor McGovern is a professor of law at Duke University School of Law and has been a visiting professor in a number of respected universities such as Stanford School of Law and others. Professor McGovern has served as a court-appointed special master and mediator and has developed solutions in some of the most significant mass claims litigations in the US. Professor McGovern is the co-author of 2 books and over 100 publications. Professor McGovern will talk about generic collective redress, allocation, and distribution.
Thank you very much, and I need to thank Judge Dowd and Sir Peter because the real fundamental point I was hoping to make to this august body is allocation and distribution as part of the alternative dispute resolution process, working with the parties to come up with an allocation and a distribution plan is absolutely critical. In fact, I would suggest a friendly amendment to your 6, Judge, and add a 7, because I think it's a grossly neglected area for judicial supervision. We've heard thus far that it's necessary to have some type of method of quantification, some methodology to be able to ascertain what the damages are and how they can be distributed in order for there to be a successful class action. At the same time, if you look at the American opt-out, opt-in phenomenon, if you have opt-out folks who don't opt out, they remain in the class action. But when the time comes to document the damages that they have, in effect, it becomes an opt-in. And the same thing regard to contingency fees. A large number of judges now will look to see, as was mentioned earlier, if there's a settlement of $50 million but only $5 million is actually distributed, then the contingent fee amount should be reduced accordingly. So I think this is a critical area, and I'll go through really 3 aspects of it that I think would be helpful for you. The design, how do you go about designing an allocation and distribution system? Implementation, once it's designed, how do you implement it? And what kinds of problems come up? I'll go through sort of a list of design factors using analogy, using algorithms, generally in the securities cases and oftentimes in the antitrust cases. These are examples in personal injury, but fundamentally the principles are the same. You develop an algorithm, for example, in the security cases, where you have a cliff and a fall off, and there may be another cliff and a fall off, and so you weight those in accordance with the amount of the damages. Sometimes we use a decision tree. A point system is used quite often, where you weight certain values by assigning them a certain number of points. You total up the total number of points, you divide the total number of points into the amount of money, and that tells you the value of each point. Presumptive models, we'll talk a little bit later about the foreign currency exchange antitrust case, where we ended up using some presumptive models. A grid is probably the most common approach. But what's important here is really the metaphor. If you look at a large number of distribution plans, what you find is if there's a disaster, if there are reparations, if it's kind of a welfare process, they tend to be flat payments, everybody treated equally. The more it looks like a tort, the more the metaphor is of a tort in assigning conceptually what the damages are, the more individual the factors. So in the securities cases, in the antitrust cases, and most of the consumer cases, you tend to be a little flatter in terms of the procedure that you use. But the underlying thought is legitimacy. What you're trying to do is assure legitimacy. And in that design, the legitimacy comes from your ability to design a distribution process that matches the gestalt of the case, that matches the reason damages are being awarded. And transparency, horizontal and vertical equity are a number of values that are absolutely critical to this. As Professor Coffey mentioned, in securities cases, it turns out in the implementation process, about 90% of the money actually goes to the big boys and girls and 10% to the small folks. Why? The mechanism is set up that way for the distribution. So understanding the way in which it's implemented is absolutely critical. We have lots of data about how different distributions for a variety of reasons have been extremely successful or not very successful at all. One of which Professor Coffey mentioned, if you're a big boy and girl, you get 50 cents on the dollar, and the smaller folks end up getting 5 cents on the dollar. But let me give a comparison here. If you look at the normal kind of response rate in the Fannie Mae case, you had 23%. One case that I did, the global research analyst cases, we actually did multiple distributions. We actually did 3 distributions, and we ended up with some money going in the Cypre process. The most interesting one, and actually Berger Montag was involved in this, was the antitrust case against MasterCard and Visa involving foreign currency exchange, where for a period of time they were charging too much in their foreign currency exchange rates. And as a result, notices were sent out after, I forgot, $300 or $400 million settlement. Notices were sent out to 30-some odd million people who had MasterCard and Visa, and the records showed they had a foreign currency exchange, even though it wasn't known exactly what the exchanges were, but they had at least one. The notices were put in the bills that people got each month. 32 million notices sent out, and the original response rate was 50,000 people out of 32 million. Thank you very much. And so Judge William Pauley in the Southern District of New York says, fix this. And so what we did was we sent out another letter that gave 3 options. Option 1, $25. Option 2, tell us how many days you spent overseas, either business or pleasure, and then we used U.S. Department of Commerce figures of roughly how much people would spend on a particular day and roughly how much would be on credit cards rather than on cash. And then option 3, if you really wanted to, write out every single one of your transactions. It turned out that at the end of the day, we actually got 12 million responses. 50,000 to 12 million responses. 75% of the folks just checked off the, I'll take a flat fee of $25, which of course, because so many people did and there's such a large response rate, we had to prorate that down to $19. But still, the principle being the implementation of the way in which you go about handling the distribution process is absolutely critical. And then the Goldilocks dilemma, you end up oftentimes with a number of scenarios that don't work very well. Too many opt-outs, too few claims, too many claims, too little money, and I'll end on a happy note, too much money. In the antitrust cases, in the average wholesale pricing, Judge Saris had more opt-outs than she had people who wanted to participate in the distribution process. Fix this, what's going on? It turned out the universe from which the opt-outs were calculated and the universe from which the people who wanted to be paid were calculated were faulty. And so by changing the universe, it turned out a lot of the people who opted out weren't qualified to be in the settlement class anyway. And then too few claims, that's the general problem that we talked about a little bit earlier. Other cases, we had too many claims. I mentioned the situation with the foreign currency exchange, too few to too many. Too little money, that happens on a regular basis, and then every now and then you get a settlement where you have too much money, and it gives you the happy event where you can make multiple distributions, and at the end of the day, give it in a cypre, which in the instance of the global research analyst was the U.S. Treasury. Thank you very much.
Well, I've requested the speaker to keep it short because of the timetable, but I'm sure that since you've shortened, there will be many questions to you later on. No, thank you for that.
At the end of the day.
Okay. Our next speaker is Professor Carla Klassen. Professor Klassen holds the chair of Civil Law and Civil Procedural Law at the Radboud University in Nijmegen. Well, I got it wrong probably, in the Netherlands, and in addition has been appointed Professor of Private Law at the University of Curaçao. Besides her academic work, Professor Klassen serves inter alia as the Vice President of the Netherlands Arbitration Institute, the President of the Dutch Arbitration for Civil Procedure Law, and as the Honorary Deputy Judge of a Dutch Court of Appeals. Professor Klassen has written several books and numerous articles on civil procedural law, tort law, and damages, and is also the co-author of one of the leading handbooks on Dutch procedural law. Professor Klassen's discussion will focus on ADR with respect to the new Dutch Mass Claims Act, which was very recently approved by the Dutch Senate.
Mr. Chairman, thank you. Ladies and gentlemen, a lot has been said already about collective redress in the Netherlands. I would like to make some remarks about ADR and collective redress from a Dutch point of view and to share some experiences and thoughts with you. As mentioned before by others, only 1 week ago the Dutch Senate approved a modified bill on the redress of mass damages in a collective action, the Mass Claims Act. Although the date of entry into force of this Mass Claims Act is not yet known, it can therefore be said that the options for starting collective actions in the Netherlands will be broadened in the near future. I would like to quote some comments on the new Mass Claims Act. Firstly, this is said to be groundbreaking and positive development for claimants. Another, if the Mass Claims Act becomes law, the Netherlands will be ahead of its neighbors on collective redress. In response to the new Mass Claims Act and focusing on the topic of this panel, I would like to set out two propositions. The first one, although the access to court and mass disputes is improved by the Mass Claims Act, ADR and particularly mediation remains a useful tool for resolving collective disputes. Secondly, arbitration cannot replace court proceedings in collective disputes, but arbitration also might fulfill a facilitating role on the way to obtaining a final court decision. I will of course explain these propositions, but first a few words on the current Dutch collective litigation regime, as well as on the most important novelties of the Mass Claims Act. Of course, I will not repeat everything that has already been said, but for a clear understanding, I would like to highlight the key points of the Dutch legal system on collective redress. For quite some years, the Netherlands has had two mechanisms for collective redress in place. The first one is the collective action for declaratory relief that can be filed by a representative foundation or association. Currently, this mechanism does not allow the claim vehicle to seek damages, but a verdict in such a collective action can provide the basis for a settlement or for individual proceedings to seek monetary compensation. In other words, the current Dutch collective action can only be used as a stepping stone towards obtaining monetary compensation. The second mechanism is based on the Dutch Collective Settlement Act, which roughly speaking, allows the Amsterdam Court of Appeal to declare a settlement reached between a claim vehicle and the wrongdoers binding on all parties that suffered damages and were represented, providing they did not opt out in a timely manner. It is discussed before. More or less in addition to this, the recently adopted Mass Claims Act allows claim vehicles that meet certain stricter requirements to seek damages in a collective action. That's the most striking new element of this act, the possibility for the court to adjudicate a collective claim for compensation of damages. There's a lot more to be said about the new Mass Claims Act, but I'll now move on more specifically to the role ADR can fulfill within the framework of collective redress in the Netherlands. As explained, currently one of the mechanisms for collective redress is to try to reach a settlement, whether or not as a follow-up to a declaratory judgment, and after that to submit a joint petition to the Amsterdam Court of Appeal asking the court to declare the settlement binding on everyone who was represented. Mediation has proven its worth in this context. Several collective settlements that have been reached and have declared binding were reached with the help of a mediator. This brings me to the first proposition. Within the scope of the new Mass Claims Act, mediation can definitely remain to play a useful role. Although the entry into force of this act allows the court to award financial compensation, a decision of the court on this matter must be viewed as a last resort solution. More in general, it can be said that even under the new Mass Claims Act, obtaining a court ruling in a collective dispute is no piece of cake, regardless of whether or not a claim for damages will be submitted. In any case, there's still much to do for the parties involved before obtaining a judgment. At various stages in the procedure under the new Mass Claims Act, the parties themselves are called upon in an effort to achieve a settlement. The first time that this occurs is right at the beginning of the proceedings. After the standing requirements are verified and some other things are in place, the court will set a time period for the parties to try to negotiate a settlement agreement. If no agreement is reached, the proceedings will continue. However, the court may order the parties to submit a proposal for a collective claim settlement before determining a collective claim settlement, if collective action is a claim for compensation and the court deems this appropriate. It goes without saying that the involvement of a mediator can offer considerable benefits in order to reach a settlement. Indeed, this provides access to different tools and to a different dynamic than available to even the most experienced litigator. Furthermore, regarding any technical hiccups in reaching a settlement, an independent expert may be brought in and asked to render a so-called binding third-party ruling or binding advice. A binding third-party ruling or binding advice is an ADR mechanism that's fairly unique to the Netherlands and provides an informal way of dispute resolution. This brings me to the second proposition, concerning the role arbitration might play in the context of collective redress. It must be stated that Dutch law does not provide for the possibility of class arbitration, in such a way that the litigant could arbitrate a claim not only for damages incurred by itself, but also for damages incurred by other persons in a similar situation. However, the lack of a possibility for class arbitration as such does not mean that arbitration cannot play a part in collective disputes. In my opinion, arbitration can have added value, particularly in collective disputes where the underlying legal issues are very complicated. For instance, if one or more non-Dutch alleged wrongdoers are involved and the legal basis of the alleged liability is disputed. Arbitration may be a helpful mechanism to obtain a decision on whether or not a legal collective claim actually exists. An institute like the Netherlands Arbitration Institute is well equipped to facilitate such arbitrations. One of the significant advantages of arbitration on this matter is the right of the parties to appoint arbitrators themselves, in order to appoint arbitrators who have specific expertise and extensive experience in the field involved. On the basis of the arbitral award, or, if that's the case, the settlement that has been reached with assistance of the arbitral tribunal, court proceedings can be started to acquire a binding and final decision between the parties concerned. In short, if the Mass Claims Act enters into force, court proceedings in the Netherlands offer far-reaching possibilities with regard to collective redress, but ADR can still serve as well as a stepping stone. Ladies and gentlemen, thank you very much for your attention, especially at this time of the day. Thank you.
Thank you, Professor Klassen. Our third speaker is Dr. Matea Durovic. Dr. Durovic is a lecturer in contract and commercial law at the Law School of King's College London. Prior to this, he served as an assistant professor at the Law School of City University of Hong Kong. Dr. Durovic was a postdoc research associate at the European University Institute, visiting scholar at Stanford Law School and at the Max Planck Institute of Private International and Comparative Law in Hamburg. Dr. Durovic worked for the legal service of the European Commission, as well as a consultant for the European Consumer Organization and the United Nations, and he will speak about EU legal framework of ADR and settlements in collective disputes.
My slides just...
This is not my expertise. How to control it, I don't know.
Did you send it?
Yes.
You send it?
Okay, it's probably on here then.
So,
Let me see if I can find it for you.
Thank you. No, no.
Which one might it be?
It's none of these, so just look at my slide. I don't know. Yeah, my slides are gone, but never mind. We'll survive without them. Good evening, everyone. First of all, thank you very much for a very kind introduction. And I would like you, first of all, to use this opportunity to thank very much to Ariel and Rabea for having invited me to this conference. I had really great pleasure and overall honor to actually participate at all three conferences. So I know how much efforts and overall how much love they have invested in trying to develop this. And I'm very, very thankful to this. Also, during the previous 2 conferences, I was based in Hong Kong, and I can tell you from the perspective of organization of this conference, being in London helps a lot, because I do not receive any more Ariel's calls at like 2, 3 in the morning to ask me to move the presentations and to help, like, just to be flexible with the organization. So really many thanks. They're not here, but still quite thank you. Again, I know it's very late, so I'm really going to try to be very late, because I imagine that you're all like me, very, very exhausted. What is the idea of my presentation is basically to speak about Rabia. You just missed my official thanking to you and Ariel, but never mind. Yeah. Yes. So what was my idea about my presentation is a paper I plan to write about collective ADR and how this is actually regulated, or rather not regulated, by the European Union rules. First of all, what is very, very important to say that the main emphasis of the European Common Consumer Policy is to try to provide a legal framework which will allow to every single consumer whose right has been infringed an effective and timely access to justice. And with that purpose, with that goal, the European Union has been investing a lot of efforts recently in trying to develop a legal framework for alternative methods for resolution of consumer disputes in situations where on the one side we have a business and on the other side we have traders, so the so-called consumer ADR. As a result, what we have on the European level are 2 pieces of legislation. The first one is Directive 2013-11 EU on alternative dispute resolution for consumer disputes, whereas the second one is Regulation EU 524/2013 on online dispute resolutions for consumer disputes. Unfortunately, there are no slides. I don't know why, otherwise you could see the full names of these 2 pieces of legislation. And the main goal, the main idea, the main purpose of these 2 legislative instruments is to ensure that all of the consumers in the European Union have access to quality insured out-of-court dispute resolution systems for both domestic and also cross-border contractual disputes. Because this is something that we would, especially in the context of what has been discussed this morning, this like global and globalization of law, it must never be forgotten that a significant part of the common European consumer policy is actually to develop to enhance the cross-border trade among different member states. And for that reason, we also have the development of common consumer rules aimed to provide also protection to consumers whose rights can be infringed in case of cross-border transactions. However, what is very important to emphasize is that none of these pieces of legislation, neither the Consumer ADR Directive nor the regulation on online consumer disputes provides any rules on collective consumer disputes, but they are primarily focused on individual consumer disputes. And the idea is how to secure that consumer ADR will fulfill the requirements of being efficient, fair, impartial, legal, etc. All of them have been very clearly enlisted in the texts of legislation themselves. And none of the 2 is actually aligned with the needs of collective redress of consumers. On the other side, when we look on the member states, so far there are 28 member states, but we don't know what's going on, no? 6 out of the 28 member states have developed on their national on the levels of their national legal orders particular rules for collective alternative dispute mechanisms, and these include Belgium, France, Italy, the Netherlands, Spain, and the United Kingdom, if we still can count the United Kingdom in as a member state, which is a good question. The recital 27 of Consumer ADI Directive is one of very, very few pieces of this innovative piece of legislation which refers to actually collective redress and which says this directive should be without prejudice to member states maintaining or introducing ADR procedures dealing jointly with identical or similar disputes between a trader and several consumers. A comprehensive impact assessment should be carried out on collective out-of-court settlements before such settlements are proposed at union level. The existence of an effective system for collective claims and easy recourse to ADR should be complementary, and they should not be mutually exclusive procedures. So we can see very, very clearly that ADR is aimed to regulate exclusively individual consumer ADR, whereas collective ADR is left beyond the scope of application of this directive. On the other side, what I would like to draw your attention, which is one of the big differences between US consumer law and European consumer law, especially when it comes to enforcement of different consumer rights, is that on the European level there is a strong opposition to introduction of mandatory ADR as the exclusive methods for resolution of consumer disputes and as part of standard terms and conditions to any kind of consumer terms and conditions offered by the trader to the consumer. And there is also this idea that every single clause of a consumer contract shall be controlled on the ground of the principle of the benchmark of fairness. We have this directive 9313 EEC on unfair contract terms, on the ground of which the European Court of Justice, as some kind of supreme European court, has developed a very, very extensive and fruitful case law. And there is Article 3, Paragraph 3, and point Q of annex of the directive, annex to this directive, which point out that excluding or hindering the consumer right to take legal action or exercise any other legal remedy, particularly by requiring the consumer to take disputes exclusively to arbitration not covered by legal provision, will be considered, will be likely to be considered as an unfair contract term. So this is this so-called gray list of this directive, which basically means that stipulation of such contract term would be most likely to be considered as unfair, whereas the businesses have to prove that such a clause of a consumer contract is actually valid and thus binding for a consumer. Moreover, what we have is very, very extensive, as I mentioned already, case law of the court, especially starting with the decision of the European Court of Justice, in this case on Mostaza Claro and some other subsequent case law where actually the European Court of Justice had the opportunity to assess the fairness of basically stipulation of arbitration as the method for resolution of consumer disputes. Now, the question is, what is the future? So, we could see that on the European level, there is not anything like legal mechanism for collective ADR. And the question is, what is the future from the policy perspective? The development of any kind of collective ADR definitely means need for development for development of a new legal instrument and for the reform of the existing legislative framework, which is something which would definitely be advantageous for cross-border trade. And again, this idea of being more, of being cheaper, being more approachable for the consumer is definitely some of the arguments that are in favor of development of collective mechanisms for mechanisms for collective ADR in case of consumer disputes. But however, as it seems now, like something that has been mentioned this morning, is this new deal for consumer from 2018, which basically represents the plan of the European Commission for the future development of the common European consumer policy, and we do not have any plans in that direction. And also, as a result of this new deal for consumers, like as a policy plan, the European Commission has developed a proposal for a EU directive on representative actions for the protections of the collective interest of consumers, which basically does not make any kind of connection between the representative actions on the one side with collective ADR and ADR general on the other side. So we need to see what will be happening in the future, but I definitely plan to write on this. I would like to thank you very much, and again to thank very much to Ariel and Rabea for this kind of invitation.
Thank you, Dr. Durovic. Our fourth and last speaker will be Mr. Daniel Stein. Mr. Stein is a PhD candidate and teacher at the Radboud University in Nijmegen. He has previously worked as a lawyer at Stiebe in Amsterdam, where he handled mass disputes such as follow-up cartel damage actions as well as other complex litigation. Mr. Stein's PhD research focuses on joint and several liability in EU and national law, and his publications are mainly in the field of European and national civil law. And in fact, he's going to speak specifically about settlement in mass disputes in cases of joint and several liability.
Thank you very much for the introduction, and especially also thanks to the organization for the opportunity to speak here today. I'm very grateful to be able to give a presentation. As already mentioned by the chairman, my PhD research concerns joint and several liability, and that's also what I will discuss today. And I will look at the impact of joint and several liability on settlements in mass disputes, and I will do that by looking at the proposal for a representative consumer action at a European level. And the question I would like to address is whether this topic, whether the influence of joint or several liability on settlements has sufficiently been addressed in the current proposal. It has already been mentioned today, the proposal as part of the New Deal for consumers. What I would like to point out is that the EU legislator relies on settlements as a means of resolving mass disputes, and as recital 26 of the proposal puts it, collective out-of-court settlements aimed at providing redress to harmed consumers should be encouraged both before the representative action is brought and at any stage of the proceedings of the representative action. So the EU legislator relies on settlements. And the importance of settlements has also been recognized in legal literature. And I think, going by the discussions today, the settlements have often been referred to. So settlements are important. Many mass disputes not only involve multiple claimants, represented by a lead plaintiff or a representative body, would also be a claim vehicle, but also multiple defendants. And in order to illustrate this, I will make use of an example of a multi-party litigation in its most simple form. And as you can see on the slide, there's just one claimant claiming 100 million in damages from two defendants who are being jointly and severally held liable by the claimant. And these defendants could, for example, be parties that are liable under product liability rules. Let's say they're just liable due to breach of EU consumer law. And the joint or several character of the liability means that the claimant can claim 100 million in damages either from the first defendant or from the second defendant, but can, of course, not obtain more than 100 million in damages because of the compensatory principle. If one of the defendants pays the full amount to the claimant, let's say the 100 million, this may give rise to contribution claims. So let's say the first defendant pays 100 million to the claimant, whereas he's only liable, internally liable, he's only share in the liability, he's only 20%, so he has to bear 20 million in the end. If the first defendant pays the full amount of 100 million, this gives rise to a contribution claim vis-à-vis the second defendant for the amount of 80 million, as his payment of 100 million exceeds his own share by 80 million, and vice versa, the same holds if the second defendant pays, in which case there would be a contribution claim for an amount of 20 million. If all parties involved, so all three parties in the example, enter into a settlement agreement, these contribution claims are likely to be dealt with in a settlement agreement. So it's likely that the defendants do not pay more than their own share, so perhaps no contribution claims will arise, but if so, that's something that could be dealt with in the settlement agreement. But what if the claimant wants to enter into a settlement agreement with just one of the defendants, let's say the second defendant? And there could be many reasons for such a settlement. A collective settlement, that is a settlement with all parties involved, may not be possible because of the dynamics between the defendants. And if the defendants, as in my example, for example, are competitors, it may very well be that there's just no willingness to enter into a collective settlement, to a settlement agreement, giving rise, for example, to all sorts of information sharing agreements. As a collective settlement may just not be feasible. And if you realize that in real life it could be more than 2 defendants, 5 or 6, as you see in cartel damages actions, the need for individual settlements becomes clear. Let's say the claimant settles with the second defendant for an amount of 50 million. And of course, the second defendant is then fully and finally released of its obligations vis-à-vis the claimant, vis-à-vis the whole class represented by the claimant. The question is, actually 2 questions arise. The first one is, what is the impact of the settlement agreement? What's the impact of the settlement on the exposure of the non-settling defendant, so the first defendant in this example? And the second question, which is related, is what is the impact of the settlement agreement on the right to contribution by the first defendant vis-à-vis the second defendant? And in particular, the second question is important because if the first defendant is able to claim contribution from the second defendant, this poses a risk on the second defendant if it's willing to enter into a settlement agreement, because it was at the time of entering to that agreement under the impression that it fully and finally resolved the dispute, but is now being confronted years later perhaps with contribution claims by the first defendant. And you may think that this is just the settling defendant's problem, but it's also the settling claimant's problem. Because if this risk is foreseeable for the second defendant at the time of settling the case, this will have a negative impact on the settlement sum that the second defendant, the settling defendant, is willing to pay. So it is in the interest of both parties, claimant and settling defendant, that this problem is solved. If you look at the national laws of the member states, and I haven't looked at all of them, but just some, especially the Netherlands, Belgium, Germany, France also, the solutions taken in the national laws of the member states reach from no reduction on the one hand to full reduction on the other hand, where no reduction means that the settlement does not have any impact on the remaining exposure of the non-settling defendant, so the first defendant in this example. That may sound extreme, but that is the default position under Dutch law. Full reduction, on the other hand, means that a settlement agreement with a claimant and one of the defendants fully releases all the other debtors, and in this case that would be the first defendant, so there would be no obligations vis-à-vis the claimant anymore if the second defendant enters into a settlement agreement with the claimant. So also quite an extreme position. And if you look at the national laws, most legal systems take a position somewhere in the middle, where the remaining exposure of the non-settling defendant or non-settling defendants is reduced partially, for example, by the share of the settling defendant. And a good example is France, after the reform of their law of obligations in 2016, where such a partial reduction automatically arises if one of the parties enters into a settlement agreement. And in the Dutch law, for example, this result can be achieved by including a contractual arrangement in the settlement agreement. It's interesting to see how EU law solves this problem, and this problem has been addressed in the Antitrust Damages Directive. If you look at Article 19 of that directive, just in cartel damages cases, the EU legislator has recognized this problem and has found a solution by stating that in Article 19, the first paragraph, a partial reduction is automatically provided if one of the parties enters into a settlement agreement. So actually the same solution as is currently taken in France. And Article 19, second paragraph, expressly states that a non-settling defendant cannot claim any contribution after a settlement from a settling defendant. So solves this problem and thereby facilitating final settlements, which is one of the defendants. One would expect that in the current proposal for representative action, this topic has also been dealt with. It does address the influence of third-party litigation funders on settlement decisions. It also does address the court assessment of settlements, but it does not address the effects of consensual settlement agreements with just one of the defendants. And in my view, if settlements are to be taken seriously as a means to resolve consumer mass disputes, this is something that should be addressed in the proposal. And that brings me to my proposition, or my conclusion, if you will, and that is, in order to ensure the effectiveness of collective redress at the European level, the effects of consensual settlements should be addressed in the proposal. I look forward to hearing your views on this, and thank you very much for your attention.
Before we move to the questions from the audience, I would like to briefly discuss one of the Israeli angles, and that is the importance of mediation in settlements before Israeli courts. As was mentioned earlier by Chief Justice Grunis, we have basically two mechanisms that assist the court in dealing with settlement arrangements in the framework of class actions. One of them is the fact that the Attorney General has the opportunity to opine with regard to every settlement arrangement, and in many cases the Attorney General files objections to such settlements. And the other mechanism is the ability of the court to appoint an independent examiner that would assist the court regarding the settlement. In fact, according to the wording of the law, the rule is to appoint an independent examiner, although we know that the courts use their discretion not to appoint an examiner, and I think that the statistics show that only in 15% of the cases an examiner is appointed. One of the reasons for that is the mediator. The main issue for the court to decide whether or not to approve a settlement in a class action is whether the settlement is proper, fair, and reasonable, taking into account the interest of the members of the class. And this is why, in many cases, both the court and the parties would prefer to use retired judges for the purpose of being mediators, because unlike regular civil disputes between the parties, where you go to a mediator mainly for their mediation skills, and the sole aim of the mediator is to bring the parties together into a settlement, and that's it. And usually when such a settlement comes before the court, in a private dispute, the court would not, unless that settlement would affect third parties, the court would simply approve the settlement. This is not the case, obviously, in class actions. In class actions, the courts need to know that not only the petitioner and their counsel and the respondents have agreed to the settlement, the court needs to know that the settlement is also fair and reasonable with regard to the entire class. And this is the main reason why the courts would prefer to see a retired judge as a mediator, because for two reasons. First of all, most of those retired judges have handled class actions when they were serving as judges. And secondly, it is very common for the parties to seek the endorsement of the mediator in such cases, not only that they would say that this is the settlement agreement, but also that they would say, we, as the mediator, believe that this is indeed a settlement that is fair and proper and appropriate for the class. And this is a safeguard and comfort for the judge that eventually has the authority to approve the authority and the responsibility to approve the settlement. So we actually see that in many cases, one of the main grounds that the courts are using for not appointing an independent examiner is in those cases where there was a mediation. Not in all settlements there is one, but if there was a mediation before a retired judge, we see this as a ground for the court to say the main issue here is the issue of the legal risk. There was already a retired judge as a mediator. I do not need to appoint an independent examiner in this specific case. The second thing that we see when there is a retired judge as a mediator, and 2 more minutes, is that even if the Attorney General objects to the settlement, the fact that the mediation was handled by a retired judge sometimes serves as a ground to justify or a signal to the court that the objection is unwarranted. And I think one of the more recent examples was the case, a class action with regard to the altoxin. In fact, the mediator sits here at the audience. The settlement was for quite a respectable amount of 45 million new Israeli shekels. The problem was, in the eyes of the Attorney General, that that reflected only 1% of the original amount of the class action. The judge in that case, Judge Groskop, at the time, well, he was already a Supreme Court judge, but he rendered that decision when, as leftovers from his district court cases, said, in this specific case, I find the settlement to be reasonable. I think that it's reasonable. He provided his reasoning, but one of the reasoning that he used was the fact that this was a result of a mediation before a retired Supreme Court judge. I think that, having said that, there are exceptions, and one of the most famous examples are a decision by the same judge, Judge Groskop, who did not approve a settlement that was a 100 million new Israeli shekel settlement that was endorsed by a mediator, a retired Supreme Court judge, not the one here in the room, and a dean of the law school of the Tel Aviv University. They both were the mediators in that settlement. It was a very significant amount, and yet Judge Groskop appointed an independent examiner, a law professor from another university. That independent examiner came to the conclusion that the proper settlement was higher, 400 million, and as a result, eventually, the court did not approve the settlement. But this is really a rare case, and it does not reflect the recent trend before Israeli courts to rely heavily on the fact that mediation occurred before retired judges. I think that now it's time to move for questions from the audience. Yes, please.
Get on my feet, get around the microphone problem. Adam Samuel, a couple of points. Go back to mediation before a retired judge. That wouldn't be really to rely on the presence of a judge as a mediator would seem to be improper unless you give the task to the retired judge of actually certifying the reasonableness of the settlement, because otherwise you're confusing the two functions. So in other words, if the appointment of the judge as mediator, retired judge as mediator, is actually indicated as including the task of approving the settlement, that's actually slightly different from conventional mediation anyway.
Well, actually, it's not the formal purpose of the mediation. The formal purpose of the mediation is to bring the parties together and come into a solution. But at the same time, the mediator does serve as a safeguard for the judge, as a signal. At the end of the day, it's for the judge to examine the settlement and actually to give a reasoning judgment explaining why the settlement is proper, fair, etc. But in many of those cases where there is the judge on the one hand, the mediator on the other hand, and the issues are really the legal risk in the claim, that's another indication for the court to say we don't need an independent examiner in this specific case.
It just seems to me, not to labour the point, that it would be a good idea if part of the mediator's instruction from the parties was only to approve the settlement if he considered it to be he or she considered it to be reasonable. Otherwise, you really do risk mixing the two roles up. Going back to a point made earlier about collective redress and ADR, one thing no one's mentioned today, so it's about time I did, some of them, most of them require the customer to actually opt in. You don't get a right to go to the Financial Ombudsman Service, which is our ADR provider at the back end, with powers about to go up, by the way, from the ability to award £150,000 to what will in reality be £350,000. And incidentally, we've got rid of retired judges, I'm afraid, for our small business complaints by expanding the jurisdiction of the Ombudsman to pick those up, along with that expansion of the, which I read previously, regulators who aren't like using retired judges.
I think that we are short in time, so we would conclude at this stage and allow the next panel to... Thank you very much.
Very good. That's the risk of allowing people to comment.
Hey. Good evening, almost good night. This is the last panel. I'm sure this is the last one. You can relax, and I'm under strict orders from the Chief Justice Grunis to keep this short. And for me, retired or not retired, this is a judicial order, so I'll comply. I'm Dolova Sano. I'm a partner in the commercial litigation class action practice in Igalonon, and our panel concerns with the role of lawyers and funders, ethical issues, and effectiveness for class members. And we're going to do this quite short, and we're going to do this in a conversational kind of way, so not a string of presentations. So I want to start off with presenting our distinguished panelists. Joshua P. Davis serves as a professor and director of the Center of Law and Ethics at the University of San Francisco School of Law. He writes, among other areas, on class actions, class action ethics, and antitrust class action. His work is both empirical and theoretical. Simon Walsh is a senior investment officer at Woodsford Litigation Funding, based in London. Prior to joining Woodsford, Simon was a cross-border litigation international arbitration specialist at Skadden Arps in London. At Woodsford, Simon has a focus on securities and other group actions, both in the UK and EU, as well as Australia and Canada. Chris Chimiklis is a founder and president and CEO of NGN Group. NGN is headquartered in Philadelphia, Pennsylvania. NGN specializes in providing notice, large-scale group claimant administration, and book building services in the United States and Europe. Chris is actively involved in several class action-related funding and book building projects in the United Kingdom and EU. Stephen Weisbrot is a U.S. attorney and the Chief Innovation Officer at NGN Group. He has a background in media planning, digital marketing, and group litigation, and as such has been responsible for some of the largest and most complex class action notice programs in U.S. history. Stephen has given public comment and written testimony to the U.S. Judicial Conference Committee on Rules of Practice and Procedure concerning the role of media in effecting due process notice. Moreover, Stephen is co-author of Duke University Law School Guidelines and Best Practices Implementing 2018 Amendments to Rule 23. And we have Noah Wortman, joined IMF Bentham in July 2018 as Business Development Manager, Global Investor
recoveries, and splits his time between Philadelphia and London with a global remit covering North America, the UK, and Europe, Australia, and Asia. Noah has extensive experience advocating for investors, promoting corporate governance, and implementing strategies to achieve collective redress. Prior to IMF Bentham, Noah most recently served as Managing Director, Americas, and Global Head of Class Action Services in London-based Gold Group. He was responsible for the company's operation and strategic vision in the Americas, and also led the company's worldwide initiative in securities and antitrust class action litigation services on behalf of its global institutional investor clientele. Noah has been a staunch advocate for investors since 1995 and has spent his career in the global securities class action litigation space, having worked earlier in his career at Kessler, Topaz Meltzer, and Czech, and later in London-based Stewart Law as Director of Case Development for the Investor Protection Litigation Department. I want to start off just with two comments on the Israeli, what I would call the Israeli paradox of ethics in class actions. And the paradox is thus. On the one hand, Israel class actions are almost always opt-out schemes, and most of them are for small sums. So the process cannot be financed through the willing participation of class members. Also, the benefits are almost exclusively for the class attorney. So the class representative gets a rather small fee. He has no incentive to finance the process. So we're left with the class attorney. However, the class attorney, from an ethical point of view, is barred from financing the client's costs, both the cost of litigation itself and the cost that might be awarded against the plaintiff if the class action fails. And also, under Israeli Law Bar Act, attorneys are also barred from sharing attorney's fees with someone who is not an attorney. So, hence the paradox, there's a disconnection between who shares the costs of litigation and who shares the benefits. This is the paradox. The enigma is how come Israel is still the class action capital east of the Atlantic. But I'm going for the defense, so I don't know. I wanted to ask Professor Davis to start it off with guiding us through just one second. Third-party litigation financing might be the solution to this paradox and this enigma. And this is just in infancy in Israel, especially with regards to class actions. So this is something that we are going to deal with. And I want to ask Professor Davis to guide us through the discussion on third-party litigation financing by giving us the theoretical framework.
Thank you very much, and thank you to Ariel and Rabia for inviting me, as everyone has thanked everyone. And thank you all for being here still, if only in body and not in spirit. I'll take what I can get at this late hour. I think we on this panel are all very much aware that this is a little bit like the 17th toast at a wedding reception. It really doesn't matter how good it is at this point, it is still the 17th toast at a wedding reception. So we have made a blood pact to move as quickly as we can. However you think our remarks in fact are, they were brilliant before we boiled them well down, and I'm going to try to do that. So very quickly, I want to start with what I take to be the theme of the day, which is that the American class action system is unacceptable, if only because it is American, but on the other hand, it may be the only system that in fact works. And given that my goals are being brief and provocative, to wake you up a little bit, I'm going to go one step further and say the American class action system does work pretty well, and if it has a failing, at least in the area I know best, which is antitrust law, antitrust class actions, which you might call competition collective actions or something similar, the failure is that it doesn't obtain enough compensation, and it doesn't deter enough. Not that it in fact goes too far. I'm going to lay out a brief case for that and then leave you all in peace. And that the solution, or at least a potential solution to that problem, is third-party funding. And so in fact, what is often taken as an ethical problem that is arising today in our system is a solution, an ethical solution. So to start off very briefly, and I will be just talking about the US system, and I will be talking about antitrust, but in some ways, and I've studied those theoretically and empirically, so I feel most comfortable in them, but in some ways it's a test case, because if compensation and deterrence are insufficient in the US system, in antitrust, where there's automatic trebling of damages. If plaintiffs wins, they win, they automatically get treble damages, and there still compensation deterrents are insufficient, then maybe it's true of the system as a whole. So let me just talk first about the specific issue I want to address in third-party funding, just to define the problem. There are lots of versions of third-party funding, and I'm only going to talk about one, and the one is loans to lawyers as opposed to clients, and loans that are specific to a case and that are non-recourse. So the lender only recovers if the lawyers recover, and secured and contingent in that way. So that is perhaps the most controversial, one of the most controversial forms of third-party funding that exist in the United States. Distinguish that, for example, from lines of credit, where a law firm, which is very common in the United States for plaintiff side class action firms, and not very controversial ethically, which is a firm just has a line of credit, there's recourse against the firm as a whole or the partners individually or perhaps both. That doesn't tend to be a problem, and it's certainly not a legal ethics problem if the client assigns rights to recovery to a third-party funder. Otherwise it may be an ethical problem, but not legal ethics. We think about lawyers. So what happened recently was that in 2018, the New York City Bar Association issued an ethics opinion which cast doubt on this particular form of third-party funding I described, where there's a lender and the lender offers a loan that is contingent and it's non-recourse against the lawyers, it only exists against the case. And what quite a few cases, quite a few judicial opinions had approved of this particular structure, but what the New York City Bar Association opinion suggested was that this was improper because under the model rules in the United States, and the actual ethical rules in most jurisdictions, it is not proper for a lawyer to share fees with a non-lawyer. And the New York City Bar Association sent some significant waves through the ethical world by saying this is the improper sharing of fees with a non-lawyer. And what the Bar Association emphasized was that there was too much of a risk of lawyers losing their independent judgment, and I think perhaps the other side of the same coin, a conflict of interest arising between the clients and the attorney. Now, just by way of background, I do want to be clear, my understanding is it's standard practice in these situations for third-party lenders to disavow any control over the litigation. That if they have any sense, in their contract, they say, we're not going to interfere with the lawyer's judgment. But the question is one, nonetheless, I think, of incentives. You could do a formalist argument, is it sharing fees or is it not? I certainly don't have time for that right now. I'm going to assume one could argue either way, and what matters in the end is policy. And what I want to put out there is that, very briefly, to say a couple of things, that in antitrust class actions, the compensation that class members receive is quite substantial, that the deterrence effects are quite substantial, but the best evidence to date, I've done some empirical work, and Bob Land has done some empirical work, and John Connor, and I'm going to just summarize that very quickly, suggests that it's actually not enough, and I want to explain why that is and why this very form of litigation funding may be a cure for the problem and not itself a problem. In terms of the evidence, next month I'm going to be putting out a study that shows that for the past 6 years, on average, in the United States, antitrust class action settlements have resulted in a $3 billion recovery per year. So over the 6 years, in nominal dollars, slightly over $18 billion, which is pretty substantial, compared to, say, the zero we kept hearing about in other jurisdictions to date. So there's that. In terms of deterrence, I have a study that I did with Bob Land. I'm happy to go into the details individually. I plan to address them, I will not. But it suggests that even in where the Department of Justice, where government enforcement is most effective, which is going after price-fixing cartels, the deterrence effects from private enforcement, measured in dollars, are actually probably greater than the deterrence effect of the Department of Justice. And I'd be happy to give you a citation or talk individually about how we arrived at that number. So why do I say, so that's substantial, that's a real benefit. Why do I say that even though that those benefits in compensation and deterrence are significant, they're not ideal, they're not optimal, they're too small? That comes from a couple of sources. I want to give you an empirical basis quickly, and then a very quickly sort of quick theoretical description of why I think it happens, or one key mechanism by which it happens. But John Connor and Bob Land, John Connor has probably the best database on price-fixing conspiracies in the world, and he took that database and he took independent assessments of the likely damages from cartels in particular cases, and he has a fairly exhaustive, within that database, fairly exhaustive information about the actual recovery in private litigation and the sanctions imposed by governments throughout the world. And what they come to the conclusion is that on average, in a price-fixing case, conspirators as a whole pay about 1/3 of the harm they cause or less. There's obviously some judgment calls in there, but it's about 1/3 the harm they cause or less, and that there are very few cases, almost none, where the conspirators end up paying as much harm as they cause. And so they say crime pays, and they've done a fairly rigorous work. You could contest it, but it's fairly powerful. And then if you add one more layer only, which is that not all antitrust violators get caught, we see a significant problem for undercompensation and under deterrence. Now, the key mechanism I want to point out, at least within the US system, is that as ethical as attorneys are, and I really do think that attorneys try to be ethical, both on the plaintiff side and the defense side, there's a very unfortunate asymmetric dynamic when it comes to settlement of class actions in general and antitrust class actions in particular. And the dynamic is that the plaintiff's lawyers expend huge amounts of time and large amounts of money, all of it contingent, and that tends to make them risk averse. They're delay averse and risk averse, and so they want to settle relatively quickly. That's how they profit maximize, even if it's at a relatively modest amount. Whereas on the defense side, the defense attorneys are paid by the hour, and so delay tends to be their friend. And so they have a tremendous advantage in the negotiation process. And that asymmetry, I think, is one of the key mechanisms for why, as robust as compensation and deterrence are in the United States, they're still insufficient. And here enter third-party funding. The form of third-party funding is often of the kind that we care about, a non-recourse loan where the plaintiff's lawyers will get some substantial portion of their hourly rate, often half of their hourly rate up front, and they trade away some of the upside at the end for that, and maybe have some or all of their costs compensated by the third-party funder. And this helps them be much less risk-averse. They lose the downside of actually being fully out of pocket at the end of the day, and because they're being paid in part on an hourly basis, they are no longer as averse to delay as they otherwise would be. So there's a very real prospect that this ethical concern is in fact an ethical cure, that third-party funding would in effect give the plaintiff side class action lawyers the backbone that it's hard for them otherwise to have. And the one piece I would add to all of this, and then I will leave you all in peace and move on to the next panelist, is there is often a false baseline. You know, the assumption is third-party funders are interfering with the independent judgment of the plaintiff's class action lawyers, and that if they weren't involved at all, somehow we would be in a pristine state where lawyers care only about promoting the interests of the clients. But the reality is there are always incentives before lawyers, and as ethical as lawyers try to be, they are in fact affected by those incentives. And so my suggestion is that third-party funding may be, in this sense, a cure, and I would suggest also, at least as a matter of experiment, to allow it for quite a while, even in this form that's been somewhat questionable, and do the empirical work and see what effect it has and whether it improves matters or makes them worse off. Thank you very much for your patience at this late hour.
Good evening. that on? It is. Hello. Good evening, and again, I'd like to repeat Joshua's points of thank you very much for staying to the end. It's appreciated. My children wake me up at 5 in the morning every day, and the only thing that's on the radio in Britain at 5 o'clock in the morning is the shipping forecast. And I realized after some time that even though I hadn't been listening to the shipping forecast, I could name all of the rocks that the various fishermen needed to know about for their daily weather forecast. So I'm hoping this evening will have very much the same effect on you, that even if you're not actually listening, by tomorrow you might realize that you've actually remembered some of the things that we've said. So I'd like to just follow on from what Joshua said actually about the ethical issues involved in third-party funding. I find it very interesting that many people will accept and agree that collective redress for consumers and others in circumstances where individuals are not able to economically bring claims on their own are a good thing. However, once we enter the question of who should pay for that, it's suddenly a very thorny issue. If you accept you're in a world where injustice will be addressed and not only be available to those who can actually afford it, then third-party funding steps in and seems to be a fairly uncontroversial thing. However, there are normally 3 ethical issues that are raised, and these feed very closely off what Joshua was saying. The first is that the use of third-party funding has fueled unmeritorious claims. I think it's certainly true to say that third-party funding has provided access to justice for many and has increased the number of claims. We've seen today that the number of claims across the globe has gone up quite drastically in some jurisdictions, and that's in part to the availability of outside funding. But I think there's a very interesting assumption built into the idea that those claims are going to be unmeritorious. I sit here today because the claims that I fund are claims that are in fact meritorious. If I was funding unmeritorious ones, I'd be out of business fairly soon. It's the job of funders, as I'm sure many of you may have been involved in funded matters, to ask lots and lots and lots and lots, and often even more, questions in the due diligence process to determine that the claim is a claim that's likely to succeed. Funders are putting all of their money at risk, and I think I slightly take issue with the term loan and lender used by Joshua to some extent. He did clarify that it's non-recourse, but in many instances, definitely in the funding that funders like Woodsford and others carry out, it's fully non-recourse in that if the claim loses, the fund loses all its money. And that feeds into the question of pricing that I'll get onto. So it's a big risk for funders, and they don't want to throw away millions of pounds quite often on claims that are not going to win on the hope that they settle, because I tell you what kind of answer I get from my investment committee if that's the proposition I was putting to them. The second issue, definitely in the UK and I think in many other jurisdictions, is that of adverse costs. And these, in the UK at least, are a very real bulwark against unmeritorious claims, especially in circumstances where if the judge disagrees with you fully, you can have indemnity costs awarded against you. And we also have in the UK something called the arc-in cap, meaning your exposure is your full commitment as a funder, including money you may have put down for security for costs. So there's very, very real disincentives to funders to be backing unmeritorious claims. The second is, again touched upon by Joshua, is that funders have undue influence on cases, how they're managed, how they're run. I think there's 2 elements to this. The first is the ethical perspective, and the second one, to be honest, is a very practical one. From the ethical perspective, there are laws, definitely in the UK and many other jurisdictions, ancient though they may be, of champati and maintenance that prevent funders being involved too closely in cases. And also, there's an association of litigation funders in the UK and also now Australia that has a, although voluntary code of conduct, one that has been judicially recognized as acceptable and sort of regulating the way funders act in a judicially acceptable way. We don't therefore control, at least reputable funders don't control claims. That's in the hands of the lawyers. The practical aspect of that being that we simply don't have the time to run claims. We're not in the business of running them. That's the job of the lawyers. I suppose where this really comes to a pinch point is the issue of settlement. And there's what some people call the first dollars issue, where funders who have put money at risk will want the return of their money quite often before claimants receive theirs. There are different regimes for this. So we heard about the Competition Appeal Tribunal regime, where there's a distribution from undistributed funds to the funder and various other mechanisms. But when it comes to settlement, there is a real risk for funders here who have claimants who do not wish to settle when an acceptable offer is put forward to them, or do wish to settle when an offer that's not very good is put to them. And that's a risk that funders take. They are not able legally to control that. Then the question normally comes, but well, if you don't control that, surely you just control the lawyers, because the lawyers are the gateway to the claimants, and the lawyers want to give you more claims so they can get more work. And again, I can tell you that's untrue, and we have to trust that lawyers are going to stand by their ethical duties and navigate the moral maze of ethics with funding in the same way as they do any other ethical issue. The final point that I was going to make was the final sort of accusation that's often leveled ethically against funders is that you make too much money, the fees are too high, and that there isn't efficient recovery for claimants, especially in class actions. This section is going to be very short. The answer is no, we don't. So I'll move on. No, I'm joking, obviously. Are the fees too high? Well, no, there are several regulatory elements to this. The first is that it's a free market economy. So there are many, many funders now in the world. There are two, indeed, on this panel. So free market economics mean that claimants and class action law firms have many options available to them now, seen particularly acutely in Australia, where funding returns have now been driven very low because there's a very saturated market, there's a very significant number of professional funders, and there's a good choice. The second way in which those fees are regulated is by the courts themselves. So again, turning to the example of Australia and many other jurisdictions, settlements are court approved, and that includes funders' fees. The same in the Competition Appeal Tribunal. Finally, I would say that in the UK, it's at the moment, well, we're currently still part of the European Union, although the big B word is going through the Parliament today, by which I mean the pricing of beer, which is currently being debated as to whether the taxes should go up or down, and obviously Brexit. But we could look to the EU for guidance. As has been discussed at length today, there's a new collective regime being proposed, which I found encouraging as a funder, because it recognized that funding was a necessary part of providing access to justice for claimants within the EU, and possibly will set out a model for a fully transparent way of funding the regulatory bodies that can bring those claims. So I think they're really the ethical issues that I wanted to address.
All right. Chris Chimicles and Stephen Weisworth from the way that NGN practices in a concept called book building, and I must admit this concept is a novelty to me, and I'm unfamiliar with it, and I think it is unfamiliar here in Israel, so I would be appreciative if you could just give us a few words on that.
Sure. So I think that to put in context the idea of book building and how it relates specifically to funding. No. Now? Great. Okay. Is this better? Wonderful. Now everyone's awake. So what ANGN does in the US and in the UK are sort of distinct from a legal perspective, but from a core competency perspective, they're nearly identical. And one has what I call the heavy influence of third-party funding, whereas the other has no influence of third-party funding, and the incentives are very different. And I'm going to have to give you just a bit of brief background so that I can drive those 2 points home. Angine Group in the United States is what is called a notice and settlement administrator, and we're typically brought into a case. We typically run into a case when there is a settlement and a judge needs assurances that the absent class members are being reached sufficiently that they feel comfortable binding those class members to the judgment. And what we do in those cases is we will take out, we will either mail, we will email, we will use media, we will use all the different sorts of tricks of the trade to communicate with class members. And then myself, as the testifying notice expert, I will explain the methodologies, I will explain why we use particular forms of media, such that the judge can determine whether or not the notice program was sufficient to bind the class. If they determine it's sufficient, you get finality, and we move forward. In the UK, on the other hand, which is where we're seeing the use of third-party litigation funding intersect with Angine's core competencies, we're being hired in an opt-in regime as opposed to an opt-out regime, where we are being paid, oftentimes, with third-party funding money to go out and use all of those same skill sets, whether it's buying radio ads, television ads, email, social media, PR campaigns, to get people to opt into a litigation. And the main difference, and the reason I think third-party funding has bared on the incentives that differ in these things is when you're doing this in the United States, all the judge is concerned with understanding is whether the class members had the opportunity to participate, right? That is the term of art, that's what a judge is evaluating. And you may buy ads in a certain magazine because it reaches a huge number of people, and therefore the judge knows enough people had the opportunity to participate. That's sort of the measuring stick by which we're determining whether or not it was legally sufficient to notice. Whereas in the UK, where we're starting before a complaint has been issued, and the ultimate goal is to get as many people to sign up as possible, we're not looking at whether we bought the best media because, frankly, the proof is in the pudding, how many people signed up. And using third-party litigation, third-party money allows us to do so much more on that front end in an opt-in regime. A lot more than might be set aside under a settlement program. Even the largest and most complex of settlements, the notice budget is kind of strictly carved out. Whereas when the incentives of the funder and the incentives of the attorneys are aligned, let's get as many people to sign up as possible, you see this sort of confluence of powers that lead to something that's greater than the sum of their parts, and you're going to see more participation than you might otherwise see under the US regime. And I just think it's interesting how the funding mechanism changes the way class members are notified. And it's something I haven't seen any real study on. But I think as we have more and more UK litigation where third-party funding is the backbone of the book build, it will make for an interesting comparison. Chris.
I mean, just to build off of what Steve was saying, I mean, for somebody like Steve, one of the novel things that you can do and the way that you can approach the book build in the United Kingdom that you can't do in the United States is that somebody like Steve can use all the proverbial arrows in his quiver to go to try to sign on these claimants. And in large part, the entire litigation, a large part of the litigation strategy is predicated on the successful part of the book build, because you can convince your funder, you can have the greatest case out there. I mean, everyone's been talking about the Volkswagen case in some varying regard today. So take the Volkswagen case. You convince your funder, they say they're going to set aside 10 million pounds or whatever the number is you agree on with them. If you don't go out, if you sign up 1,000 claimants, then you're not going to move forward, whether it's IMF or Woodsford, you're not going to move forward with, filing the case because you haven't aggregated enough claimants to move forward. So, the importance of building your book and using all the different tools at the disposal is very important. And I think we saw, and I don't think our friends are in the audience anymore, but our friends at the SPG Law Group who were here earlier today really took a novel approach with how they approached the book build in Volkswagen in the United Kingdom. And, you know, I think they took a really interesting, unique approach in terms of, you know, just sort of the integrated media approach that they utilized in terms of, it wasn't just sort of a, you know, a digital or social campaign, but, you know, utilizing radio and billboards and a PR campaign, and just sort of just really, you know, this really unique approach, sophisticated approach, and frankly one that we can't really even employ in the United States often, because we're more hamstrung in terms of our approach with how we're able to even approach it in settlements in the U.S.
And that's procedural, right? Because when you're doing a book build in an opt-in jurisdiction, you're being paid by plaintiff's counsel or their funder, and you haven't issued your law, you haven't issued yet, right? So the defendant doesn't have the ability to dictate, you know, their reputational concerns are not, they have no seat at that table, right? The notice providers in the US can only go so far, because there's plenty of times we have novel ways of reaching people, and we could take out, for example, you know, digital billboards all over the cities. They're saying, well, that's a smear campaign. But when you have third-party funding and you have an opt-in regime, they don't have a seat at that table, and it allows companies like ours to go out there and give you the full suite of services and treat a book build the way Madison Avenue would treat an advertising campaign. And you can't do that under Rule 23, the way in the sort of paradigm and the dyad that it's structured, because there's just there's A, no budget, and B, there's countervailing arguments by the defendant that it's too much. You know, you're using an atomic bomb to kill a gnat, but we're being criticized for the lack of participation. Well, those are the reasons why in the U.S. you're seeing lack of participation, because we're not able to use to take Chris's phrase, arrow in our quiver to go out there. Nick?
Could you see yourself ever aggregating claims for mass arbitration? One of the things we haven't talked about today is the influx and decline of arbitration clauses and their impact on class actions in the States. Have you ever thought about that? Is that something where this would be appropriate?
Sure. So, I mean, it's the absolute same skill set, and you're right, you sort of cut out the defendant's seat at the table by doing that. I mean, I'm sure many people would kind of watch that Uber where they aggregated all the claims, and you know, Uber was required to pay for the arbitration costs. All of a sudden, Uber wanted a class action, right? You know, it's kind of the incentive switch from one foot to the other. But you're absolutely right. If the goal was to aggregate claims in the U.S. and then file hundreds of thousands or more, or tens of thousands individual arbitrations, it would be the exact same paradigm as a opt-in jurisdiction. Yeah, good point. Noah?
I think the thing that we could take away from the panel thus far, in combination of what Josh and Simon have said, and Chris and Steve have said, in combining the notion of access to justice, I think fundamentally at its core, third-party litigation funding has allowed for those people that are out there, whether it's consumers or institutional investors, to gain entry to a system that varies from country to country and jurisdiction to jurisdiction. And when you're talking about an opt-out jurisdiction versus an opt-in jurisdiction, it allows for those folks that wouldn't have ordinary access to opting into these cases, whether it be lack of education, lack of resource, no matter what type of the resource it is, that door opening and that support. So for all the reasons that Simon said, you know, that there are ethical prophylactics in place in the considerations that litigation funders undergo when they're examining a case, the deep due diligence that gets done, I can speak from IMF's standpoint that our investment committee is extraordinarily conservative, so maybe for every 200 cases that we review, we may only accept and invest in a handful, a very small handful. And then there's incentive in the agreements that are put together with
the claimants and the partnerships that are formed with the law firms for everybody to have some skin in the game. So there's incentive to take on the meritorious cases and also to not file the frivolous cases because then that would just be lost money for everybody. But my point in combining the 2 points here, the book build versus what Josh and Simon were talking about, is because it allows for other participants in the overall picture to improve their ethical standards as well. So from where I stand, and I tend to concentrate in shareholder litigation in Europe and some in the US and elsewhere, in the opt-in regimes that exist in Europe, it allows for institutional investors who have resource issues or have other higher priorities in some instances, third-party funding, that's non-recourse funding, that allows them to have the feeling of a contingency fee arrangement, the feeling, not the actuality, but the feeling of a contingency fee arrangement that they're used to in passively participating or maybe actively participating in US litigation, to allow them the opportunity and the affordability and working with expert counsel and experts in the literal fields of these litigations to gain entry into that door and be able to seek redress for monies that they may not have been actually able to go after from a resource standpoint. And from that standpoint, it allows them from one could argue from an ESG standpoint, being a good steward within the institutional investor community, if you're an institutional investor, to promote those governance concerns in a positive way internally and adhere to those mandates that you may have in-house and within the greater community as well. And in turn, the book building capability, whether it's being done with a firm with Angian or a number of the litigation funders also do book building on their own or in combination with firms like Angian for these types of cases, it gets the word out. You know, and it allows for people to have access to that expertise and to make an educated decision and allow to seek that type of redress.
One last question for the panel before we let you all out. Since third-party litigation funding in Israel in generally and specifically with regards to class actions is really in its infancy, if you could give the Israeli audience, whoever is left here, one good lesson, one thing that you would want us to pay attention to, maybe change from what you're used to, or maybe keep.
I guess the takeaway, and I think this is something that everybody's already doing, otherwise we wouldn't be sitting here at past 7 o'clock in the evening, is learn from your peers around the world and be open to those conversations and see what's going on in other countries. And don't be afraid to stand up, and if there's something that makes sense to implement here that's going on elsewhere or vice versa, then to take that stand and be open to those conversations.
Yeah, I agree. If you can blend different things that you've seen in different jurisdictions that work well and create your own sort of utopia system, you know, go for it.
I'm not intimately familiar with the Israeli system of notification and distribution, but I do know that there's been considerable criticism on the way distributions are undertaken, and using sort of this register in terms of notification, to me is error for a lot of reasons. One is the money doesn't get into the hands of the people who rightfully deserve it. Two, it propagates this idea that class actions are just for the attorneys, something you essentially said earlier, and I think it's sort of an institutional failure to not use the best practices that have been clearly established around the world in order to effectuate those goals. And I think it's very easy to lean on guidance, and this is not a sales pitch, but from other jurisdictions and other professionals. I think that Israel would do well, given the volume of class actions, to maximize participation rates.
I would say allow third-party funding. Specifically, But as a serious point, I think two lessons. One, don't be afraid of collective redress and class actions. It's easy when they start to accelerate at the pace that they are in Israel and other countries to become frightened that they're overwhelming and that there'll be too much chaff and not enough wheat. That shouldn't be feared, I think, especially if you combine it with third-party funding, because that provides an additional layer of diligence to those cases, and it provides certainty for claimants and access to justice for them.
And I would just say, beware of thinking that whatever you do now is natural, and any change from that is a distortion and somehow corrupt. We tolerate huge levels of unenforced rights, incredibly limited access to justice, and so think critically about what your current system is and not treat it as sort of with a false neutrality, and how some of these innovations may in fact improve the enforcement of rights under law.
I want to thank all of you for your great stamina, for keeping up till now, and thank you very much.